So here are the general rules if you want to move out. Before we get to the special rules for special needs, it's important to understand the general rules. So one very fundamental principle of housing law in Quebec, which is very different from some other places, is we have automatic renewal of our leases. If you don't do anything, your lease is automatically renewed. And some people don't realize that and think, well, okay, my lease is ending June 30th. I'll just move out June 30th because that's when it ends. That's a mistake. If you don't do anything, your lease will be automatically renewed for another year and you'll remain responsible for the rent. So if you want to leave at the end of your lease, you have to give 3 months notice before the end. Now, that's the general rule for a 12-month lease, which is what most people have. You have to give 3 months notice before the end of the lease. So the vast majority of leases in Quebec, as I'm sure you know, run from July 1st to June 30th. What does that mean? That means that at the latest, you have to give a notice by March 31st, 3 months before, that you want to leave. Otherwise, your lease, as I just said, will be automatically renewed. Now, if you get a rent increase notice, because the rent increase notice could come as early as the beginning of January for the typical July to June lease. So you could get a rent increase notice the 7th of January, for example. In that situation, you have to answer within 1 month. And if you want to leave, you have to say within 1 month of your notice. So again, if you get it January 7th, you have to answer by February 7th, saying that you want to move out. If you don't do that, then your lease will be automatically renewed, which could put people in a difficult situation sometimes because you may have to decide very early in the year, as early as early February, whether you want to stay or not. But that is the law in Quebec, so it's important to know these general rules. Now we're going to look, so we'll move on to the next slide. We're going to start to look at the special rules. So moving out due to special needs. So normally you have to wait till the end of your lease to move out. So you have a lease from July 1st to June 30th. You have to wait till June 30th to move out. But in certain situations of special needs, you can end your lease early. You don't have to wait until June 30th. So here are the exceptions. If you are moving to a seniors residence, which could even be a private residence, as long as it's designated for it provides services to seniors, that will allow you to end your lease early. We're going to look at how you end it early in a moment, but just now we're looking at what are the situations in which you could end it early. So moving to a seniors residence, if you can't continue in your apartment due to a disability, okay, so for example, maybe your apartment is not adapted at all. Maybe your apartment has the front entrance has a long set of stairs, and due to a mobility issue, you can't get upstairs anymore. These would be the type of situations where you could not continue living in your apartment due to a disability. You would be able to end your lease early. If you are accepted into government low rental housing, commonly called HLM, hébergement à loyer modique, HLM in Quebec, that would be another reason that would justify ending your lease early. A person who is a victim of domestic violence is also allowed to end their lease early. Okay, so those are the situations. Now we're going to look at how you go about ending your lease early. Okay, so for a 12-month lease, you must send the notice to the landlord at least 2 months before. So let's say, for example, you want to leave January 1st coming up. You would have to send the notice by November 1st, okay? And for a shorter lease, let's say you have a 6-month lease, not that common in Quebec, but you would have to give only 1 month notice, okay? So instead of having to wait until June 30th, that's when your lease comes up for renewal, like most leases in Quebec, you could, for example, if you want to leave January 1st, you could leave January 1st if you're in one of the special needs situations that we looked at in the last slide by sending a notice on or before November 1st. Okay. And we'll move on to see what you have to put in the notice. So how to do it. So you have to include a proof, some proof of your situation. So for example, it might be a certificate from the residence stating that from a senior's residence, stating that you've been admitted. It might be a medical assessment, something from a doctor saying you can no longer stay in your apartment due to disability. So using the example I used before, your apartment and your building is not at all adapted. It has a long set of stairs to get into the building, no ramp. Now, for example, you're unable to walk upstairs, whether it's because you're in a wheelchair or some other type of disability. That would be an example, but you would still need a letter from a doctor explaining this. No payment to the landlord is required. You do not have to pay any kind of penalty, whether it be an amount of rent, whether it be some other sum of money that the landlord might think to ask you. It's simply illegal for the landlord to require it. And as mentioned earlier, the rental board has a form you can use to notify landlord. Again, at the risk of repetition, you don't need a special form. You can write a simple letter and attach the proof. It's always good to send it by registered mail, so you have complete proof that the landlord received it. There can be no dispute where the landlord says you never sent me a notice. So a simple letter is fine with the necessary proof, such as the letter from the doctor or the certificate from the residence. But another option is to download a form from the rental board website, fill in the blanks, and again, attach the proof and send it to the landlord by registered mail.
With regards to people who live in rental apartments or rental buildings, and there's a change in their, say, mobility issues, or there's some, I don't want to use the word minor, but kind of lower grade disabilities, and specifically if seniors have been living there for more than 5 years, do landlords have a legal obligation to retrofit the apartments to kind of help their tenants?
I don't think so. I must say I haven't faced that question before. I know the rental laws pretty well, and there's nothing in the rental laws itself that says that. So it'd be some kind of other provision. There is a specific Quebec office of the rights of handicapped. And if there is any legal requirement in that situation, they would know about it. In the rental law itself, which is the civil code actually of Quebec, it's part of the civil code. There's nothing that says a landlord has that obligation, which is probably why the tenant has the option to leave, to go elsewhere, because there's no specific, nothing specific in housing legislation that would oblige a landlord to do that.
I got a bit of a left field kind of specific question at the same time. So for people, just the questions you love.
Yes, exactly. I was going to say the tougher, the better.
There we go. So for people who live in rental apartments and buildings, so let's say they know an individual knows that their mobility is getting more compromised, say, and they live in a walk-up. When they get notice that their lease has to be renewed, can they say to their landlord, "Hey, I want to move down to the first floor"? Is that kind of something? Is that a kind of compromise that someone can do with their landlord, and then hopefully they get the same rental price?
Okay, so if the question is, can they say this or can they ask this?
Yeah.
100% yes. If the question is, can they oblige the landlord to give them a downstairs apartment? The answer is no.
Perfect.
So in general, there's a lot of rules protecting tenants, but in its essence, a lease is a contract. And you can't force someone. Basically, you're saying, I want to give up this contract. I'm going to end this contract. I want to enter into a new contract with you for the downstairs apartment. And that's perfectly legitimate, makes good sense if the apartment is going to become available, but you cannot in any way force the landlord to do that.
If you're in a residence and you give notice that you're leaving, do the services continue until you leave? the residents?
If the services are part of your lease, then normally they would continue as long as you're there.
Okay.
Once again, unless you renegotiate something.
Okay.
Okay, we're talking about usually a fairly short period. If you're going to a different living situation, you want to leave in the next few months, you give the 2-month notice. So normally your needs haven't changed and your services, I mean, I would assume you would want your services to continue until you leave.
So this person says that they live in a building run by a rental business corporation. This person first signed a legal Quebec document lease for 23-24. A renewal letter was sent to this person for 24-25 with no legal forms. There was no form to respond. Is this a normal situation? And then this person says they sent a short letter to renew by registered letter, but that basically in the renewal lease there was no legal Quebec document form to be signed.
The landlord doesn't have to provide a form to sign. The landlord has to inform you let's take the typical rent increase. Landlord has to inform you that they're asking for, let's say, 5%, that you have the right you have different options, the right to leave your apartment, of course, the right to accept the increase and stay in your apartment, and the right to stay in your apartment but refuse the increase. So you got 3 options: leave, accept the increase, or stay but refuse the increase. The landlord has to inform you of those 3 things. They don't have to provide you with a form to answer them, and they don't have to send it on a specific legal form. The lease itself that you sign when you move in, by law, must follow the official legal lease form. But from then on, simple letters are okay. So it's okay for the landlord to send you a simple letter. It's okay for you to answer with a simple letter. Although you do have the option that I mentioned before, I even mentioned for the rent increase situation, that the rental board itself, if you prefer, has a form that you can download and fill out. If you prefer to use an official type of form where you just fill in a few blanks, that's available for you as well.